For more than a century, government officials in New York decided who deserved the right to carry a firearm and who didn't, not based on criminal history, not based on training, but based on status, connections, and discretion. That system collapsed in a single Supreme Court decision. In June of 2022, 6 justices dismantled a permit scheme that rejected ordinary Americans by the thousands while quietly approving applications from judges, politicians, and the well-connected. That ruling didn't just change New York law. It triggered a legal shockwave that is still tearing through courts in 8 states right now. And most Americans have no idea how big this really is. The case didn't start with wealthy donors or political power brokers. It started with 2 ordinary men, Robert Nash and Brandon Coe. They weren't celebrities. They didn't have lobbyists. They didn't have influence. They were New York residents who wanted the ability to protect themselves and their families. Robert Nash did everything the state asked of him. He completed firearms safety training. He passed every background check. He had a clean record. The licensing officer denied him anyway. Why? Because under New York law, simply wanting to defend yourself and your family was not considered proper cause. Brandon Coe faced the exact same outcome. Neither man could prove that they faced a special danger different from every other law-abiding citizen. That wasn't a mistake. That was the system working exactly as designed. Under New York's Sullivan Act, passed in 1911, licensing officials were given nearly unlimited discretion. For over 100 years, they decided whose constitutional rights mattered, and the numbers exposed how corrupt that discretion had become. In some counties, fewer than half of 1% of ordinary citizens were approved. Meanwhile, judges received permits almost automatically. Retired police officers received permits, wealthy executives received permits, politicians and their friends received permits. Regular working Americans were denied. The New York State Rifle and Pistol Association took the case to the Supreme Court, and Justice Clarence Thomas delivered a 6-3 opinion that demolished the system from the foundation. But the court didn't just strike down New York's proper cause requirement. It changed the legal rules of the game entirely. The court established what is now known as the text, history, and tradition test. From that moment forward, governments could no longer justify gun laws using modern policy arguments. Crime statistics no longer mattered. Public safety studies no longer mattered. Polling data no longer mattered. Expert testimony no longer mattered. The only question that mattered was this: did a similar regulation exist at the time the Second Amendment was ratified in 1791? And for most modern gun laws, the answer is no. Judges across the country began digging through colonial records, early American statutes, and founding-era legal texts. They searched for historical limits on magazine capacity. They found none. They searched for bans on firearm features. They found none. They searched for age restrictions on adult firearm ownership. They found none. They searched for broad, sensitive place bans covering cities and public spaces. They found almost nothing beyond courthouses and legislative chambers. And as a result, modern gun control laws began collapsing in federal court. Magazine capacity limits fell because no historical analog exists. Assault weapon bans began failing because Americans historically owned weapons suitable for militia service. Age-based sales restrictions crumbled as courts recognized that 18-year-olds were expected to own arms and serve in militias at the founding. This wasn't incremental change, it was a legal earthquake, and the effects were immediate. 8 states, New York, California, New Jersey, Maryland, Hawaii, Massachusetts, Connecticut, and Rhode Island, had all operated under may-issue systems that relied on bureaucratic discretion. Overnight, those systems were unconstitutional. The floodgates opened. Hawaii offers the most dramatic example. Before the ruling, the entire state had issued just 187 active carry permits for 1.4 million people. That's an approval rate so low it was effectively zero by design. Within 8 months of the Supreme Court's decision, Hawaii processed more than 3,800 applications, and approval rates jumped above 80%. The gatekeeping system collapsed. California saw the same phenomenon. Los Angeles County had issued roughly 400 permits for a population of 10 million. After the ruling, officials were overwhelmed by more than 8,000 applications in just 6 months. New York's licensing offices, which previously processed about 5,000 applications per year, were hit with over 60,000 almost immediately. The state was forced to hire dozens of new employees at millions of dollars annually just to process applications that had been denied for generations. These states became shall-issue jurisdictions whether they wanted to or not, but they didn't accept that outcome quietly. Instead, they launched a new strategy: bureaucratic warfare. California passed Senate Bill 2, declaring vast portions of public life to be sensitive places where carry is banned. Government buildings, public transit, parks and playgrounds, entertainment venues, libraries, medical facilities, banks, even private property was declared off limits by default unless the owner posts explicit permission. In major cities, legal analysts found that permit holders often cannot walk more than a few city blocks without entering a prohibited area. The permit exists on paper, but is nearly impossible to use. New York moved just as aggressively. The legislature passed emergency laws creating dozens of sensitive place categories, including entire neighborhoods like Times Square. They went even further, attempting to require applicants to turn over years of social media history so officials could judge their character. Federal courts struck down the social media surveillance, but much of the broader framework remains tied up in appeals. New Jersey and other states followed with their own layers of restrictions. The strategy is clear. If permits can't be denied outright, make them functionally useless. But there's another factor driving resistance that rarely gets discussed: money. The firearms training and permitting industry generates an estimated $1.3 billion annually. California requires up to 16 hours of training, costing hundreds of dollars per applicant. With tens of thousands of new applications, training providers collected tens of millions almost immediately. Maryland's training mandates generate similar revenue streams. Federal courts are now questioning whether states can impose expensive requirements that didn't exist at the founding, especially when they price low-income Americans out of exercising a constitutional right. In 1791, Americans purchased firearms without permits, background checks, or mandatory courses. If these training mandates fall, an entire industry collapses overnight. Right now, more than 300 active federal lawsuits are challenging gun laws under the new constitutional standard. Appeals courts are split, states are losing cases, Supreme Court review is increasingly inevitable. The legal avalanche is accelerating. This all began with two ordinary men who were told they weren't important enough to exercise a right. Now, the system that denied them is under siege nationwide. The question is no longer whether the law has changed. It's whether state governments will follow the Constitution or continue trying to work around it. Drop your thoughts in the comments and subscribe, because the next Supreme Court decision could change everything again.